Good afternoon. This is the meeting of the Board of Adjustment of the Municipality of Anchorage of July 9, 2015. I'm Baron Puccio, Chair. Madam Clerk, would you please call the roll?
Baron Puccio,
Here.
Dwayne Adams,
Here.
Bob Stewart.
Here.
Also present is Julia Tucker, Board Counsel, and Lisa Slusner, Board Support. We have a quorum.
Thank you. The first thing we need to do is take a look at the agenda for this evening, for this afternoon and this evening. It's a combined agenda here. Any additions, changes, deletions? Anything at all? Mr. Stewart?
On the receipt of the two petitions, does that refer to?
We will attend to that in a minute.
No, I don't have any changes.
Okay. I do not have any changes either. Seeing that there are no changes, the agenda is approved. Next item is the review of the minutes of our meeting of May 27, 2015. Have we had an opportunity to review those minutes?
Yes.
And any changes, additions? Mr. Stewart?
The only thing would be to council's memo was available by, I don't have that date with me, but the rest of it, everything that I looked at in there, it's exactly like we had agreed.
Okay. Mr. Adams? Any
No,
changes? Okay. The only thing that I saw was under item number 10, adjournment. It wasn't John Haxby who seconded that. He wasn't here. That was instead Dwayne Adams.
Thank you.
So we should note that change. And in the next line, the meeting was scheduled for June 17, I believe, not June 24. With those changes, any more comments regarding the minutes? Seeing no changes, the minutes are approved as amended. We then come to old business. I don't see any old business here. Anyone have old business? Seeing none, we're rolling right along here and come to item 6A, new business. And that is the motion for reconsideration that was filed by the Municipality of Anchorage regarding Appeal 2014-5. And that's what we need to address at this point. There is a preliminary matter that we need to address first in connection with that motion for reconsideration. There were two so-called petitions received by the municipal clerk. One filed by Mr. Feller on July 8th, and one filed by Ms. Nolan on July 9th, today. In looking at this as the chair, I note that by city ordinance, municipal ordinance, and that is 213170C, requests for reconsideration must be filed within 15 days of the original decision. And you will note that the decision was dated June 1, 2015. And reconsideration can only occur with, for one of three reasons specified in that section. So in looking at these documents, it appears that, first of all, there is no such thing as a petition that we can consider. So if we consider those to be required requests for reconsideration, the only thing that we can do, and are allowed to do by ordinance, they were filed untimely, i.e. outside the 15-day window specified by 213170C. And so it appears that they should be disregarded and should not be included in the record on appeal. And in order to quickly discuss this, I will move to disregard the petitions filed by Tim Feller on July 8 and by Heather Nolan on July 9, and to exclude them from the record on appeal. May I have a second, please? Second. Has been moved and seconded to exclude those. I intend to vote for the motion for the reasons stated. It is clear that we are restricted to requests for reconsideration within 15 days of the original decision. These were filed outside, so they should be excluded for that reason. The fact that they are styled as petitions, to my way of thinking, is immaterial. They perhaps should be considered late file motions for reconsideration at best. But I intend to vote for the motion and refer to Mr. Stewart, who seconded the motion. Excuse me.
I concur with your analysis, and I think I'm going to be supporting the motion.
Okay. Any further discussion regarding that motion? Yes, Mr. Adams.
I just have a question. So what is the distinction between that and GCI's opposition to the motion?
They did not file a motion, they simply filed a simply filed a response. Now, the code doesn't allow for that, but I view that as fairly insubstantial. They are not raising any issues. They are simply responding to a motion that was made by the municipality. Okay.
Yeah, I think it's worth noting then, with respect to that there's nothing in either the Feller memo or petition, however you want to phrase that, or the Nolan that refers specifically to the request for reconsideration, just to make the distinction between it and the GCI response.
Okay. All right.
And so with respect to that, I do want to disclose, I did read these.
Okay.
So just so that that's on the record. But I do support the motion recognizing that difference.
The fact that you read it, as long as it does not have a bearing on your discussion on the decision in the motion for reconsideration, I think that's what counts. I have no further discussion. Please vote.
Garrett Goodchild,
Yep.
Robert Stewart,
Yes.
Dwayne Adams.
Yes.
And the motion passes 3-0. All right, we will then come to the main item here, and that is the motion for reconsideration filed by the municipality. We had decided the GCI matter, and I must tell you, I personally felt pretty good about the decision. Little did I know that it would stir some controversy and in fact then raise something within the municipal attorney's office or maybe within the planning department that caused them to file a motion for reconsideration. And I should note first that the motion was filed in a timely manner. As I said before, EMC 213170C controls motion for reconsideration. Under that section, a decision by the Board of Adjustment may be brought up for reconsideration or rehearing only if A, there was substantial procedural error in the original proceeding, or B, the board acted without jurisdiction in the original proceeding, or C, the original decision was based upon fraud or misrepresentation. So that then leads us to the first issue that we need to consider, and that is, does the motion for reconsideration filed by the municipality of Anchorage identify the correct grounds for reconsideration? And specifically, since there's no assertion here that we acted without jurisdiction or that the original decision was based upon fraud or misrepresentation, does the motion for reconsideration by the municipality identify substantial procedural error? And in order to get this issue on the floor and to discuss it, I will entertain a motion by one of us here that the motion for reconsideration does identify substantial procedural error.
So moved.
All right, has been moved and
Second.
seconded by Mr. Stewart. To consider, yes, ma'am.
I just would ask for clarification. There's a couple of issues. One would be whether the motion for reconsideration identifies substantial procedural error, and the other would be if there is substantial procedural error otherwise identified by the board. So I just want to make it clear and understand which way.
Well, we are only considering the motion as it was raised by the municipality in its motion.
Okay.
Yes, sir.
The way this is stated, this doesn't preclude us from looking at other substantial procedural errors.
That's right.
We're looking at only what is set forth in the motion for reconsideration right now.
Correct.
Okay?
Right.
Correct.
And so, depending on what the board intends, I know we've had this discussion before here, but let's just say that the board's decision was gonna be that the motion for reconsideration itself did not identify substantial error. If you phrase the motion as does and then vote no, then you've denied, it's like, okay, there's no alligators. I mean, you need to
Well, if you would like it to be phrased the other way around, to comport with your objection, then it should say, the motion for reconsideration does not identify procedural error.
Right, and then that you can answer if your intent is to.
Okay, all right. So I view that as a friendly amendment. Is that accepted by you, Mr. Adams, and by you, Mr. Steele?
Yes.
All right, so the motion correctly should read, the motion for reconsideration does not identify substantial procedural error. And Mr. Adams, you are the one who made that motion. Would you address it, please?
Well, I think there's a lot of things that are troubling about that. Certainly, first and foremost is why wasn't this brought, the facts that they allege in the case as that they try to make, why was this not brought forward as an input to our original decision? So the fact that it's brought at this and it tries to use a procedural error to argue the basis for the finding is a little bit troubling. And there is a question of whether this is a procedural error that they say exists or whether it's a matter of law. And I think they're arguing procedural error, and the real discussion is a matter of law. I don't think they have a standing with respect to the argument that they make.
Okay. So your intention is to vote how on the motion that you made?
I will vote aye, yes.
Okay, Mr. Stewart.
I concur with Dwayne. In this case, it looks like what the municipal attorney has done is that they're arguing a substantive argument, but they're calling it something else, which is substantial procedural error. So I think it's something that would and could be entertained in a different venue, but not in this particular venue under procedural error.
Okay, and so you intend to vote no on that one?
I intend to support it.
Okay. My comments are these. The motion itself talks about a procedural error, but it doesn't identify it. I agree with Mr. Adams that what they're really raising is a substantive issue that they should have brought up earlier. I do not view that as a substantial procedural error that we committed. And so I intend to support the motion as well. Any further discussion? Seeing none, Madam Clerk?
Barrett Goodchow,
Yes.
Robert Stewart,
Yes.
Dwayne Adams,
Yes.
All right, we then come to the issue number 2. And that is this: in reviewing our decision of June 1, did the Board of Adjustment confirm substitution of its independent judgment by majority vote on factual matters supported by substantial evidence in the record as required by AMC 2130-090D? And in order to raise that, I will entertain a motion that the board recognizes that it did not formally confirm substitution of its independent judgment by majority vote as intended in the findings and decisions of June 1. May I have a second, please?
Second.
All right, moved by myself and seconded by Mr. Adams. In reviewing what we did on June 1, we did substitute our own judgment. In effect, we took a shortcut and simply said the decision is changed, and then we changed it by confirming that the conditional use was approved. But we did not formally substitute our own judgment for that of the Planning and Zoning Commission as we need to do. And so, for that reason, I would find that that we did not formally confirm substitution of our independent judgment by majority vote as intended in the findings and decisions of June 1. Mr. Stewart.
I think that's correct when you look at what we did. And we followed the general rule, but we did not actually make a ruling exactly on point. So if we do that, then I think that would correct it. I intend.
That would, assuming the motion passes, that would be the next step.
Right.
obviously.
Yeah, yes, the next one.
Okay. Mr. Adams.
I would add that in a lot of our discussion, we explicitly stated that that's what we were doing. We stated that over and over, but that simply didn't get made as a motion.
As a motion, it
And
wasn't over.
integrated
Yes.
into the findings or the motion
Okay.
itself.
I think what we are referring to in this motion is findings 30 to 32. And we are obligated under 213190D, if we substitute our independent judgment on factual issues, to make that motion specifically, as Mr. Adams just stated, and I think we failed to do that. So that follow-up motion relating to findings of fact 30 and 32 do not reflect that, and I think that was a deficiency in our previous decision. Any further discussions regarding the motion? Seeing none, Madam Clerk?
Baron Gutschall,
Yes?
Robert Stewart,
Yes.
Dwayne Adams.
Yes.
All right, so having found that we omitted a procedural step, the issue then presents itself. Does this board find that substantial procedural error occurred in the failure to formally substitute the board's independent judgment for that of the Planning and Zoning Commission to approve the reduction of the minimum separation distance to waive the 200% fall zone? And to raise this issue, we need to go through a two-step process. The first one is that I would entertain a motion that the board recognizes substantial procedural error in the board not perfecting its substitution of independent judgment on factual issues by an affirmative vote of 2/3 as required by AMC 213009D. Could I have a motion to that effect?
So,
Mr. Stewart, and second.
Second.
Moved and seconded. Mr. Stewart.
well, by the mere fact that the municipal attorney was obviously confused about what we were doing, there's a good chance that any further review authorities would be under that same guise. They'd be working under that same guise. So I think it's appropriate for us to recognize that it is substantial procedural error on our part, and for us to change that.
Okay. And so you intend to vote
I
aye?
intend to approve.
Vote for approval. Mr. Adams.
And Mr. Stewart states that as well.
Okay. My only comment is this. It is this board's obligation to issue its decision in writing and base it upon findings and conclusions that are reasonably specific so as to provide the community and, where appropriate, the reviewing authorities a clear and precise understanding for the board's decisions. And it is clear to me from reviewing the motion for reconsideration by the municipality that we failed in that regard, because if not even the city attorney's office can figure it out, there's clearly something amiss. And so, in order to rectify that problem, it is apparent to me that procedural error occurred here that led to the decision of June 1, and that we need to rectify that. It is for that reason that I intend to vote for the motion. Any further discussion? Seeing none, Madam Clerk?
Baron Gutschall,
Yes.
Robert Stewart.
Yes.
Dwayne Adams.
Yes.
The motion passes 3-0. All right then, having found that we committed a procedural error, the next question then is how to rectify that. I believe that in working within the framework of the decision that we rendered on June 1, 2015, we can correct it and amend it. And so I will move that the board finds its procedural error sufficiently substantial to warrant correction, and the findings and decisions dated June 1, 2015 is to be amended to confirm the board's determination to substitute its independent judgment on factual matters supported by substantial evidence in the record in procedural compliance with 2130-090C and D without rehearing, to include additional findings. We will leave it at that for the time being. May I have a second for that motion, please?
Second.
Mr. Adams has seconded the motion. I think if we were to add a paragraph that to our findings of June 1, 2015, we can correct the apparently confusing decision that we rendered. And it is for that reason that I intend to vote for the motion. Mr. Adams, I think you seconded that.
Yes, and I agree with that. I think it's a simple matter of providing the language that clears up those items that were identified in error by the municipal attorney, specifically with respect to how we were acting with respect to acting as a matter of law, as well as how we were substituting our independent judgment.
Okay. Mr. Stewart?
I'm going to be voting in favor of this just because it does clear up the misunderstanding.
Okay. Any further discussion? Seeing none, Madam Clerk?
Eric Goodchild,
Yes.
Robert Stewart,
Yes.
Dwayne Adams.
And the motion passes 3-0, I should say, apologize. All right, then we come to the substantive aspect, and that is how to clarify this. Our counsel has provided us with a suggestion to add a paragraph 33 to the decision of June 1. And I would like you to take a minute to review that proposed addition, please. about that? Okay. I will move that we add a paragraph 33 to read as follows. And that is in addition to the decision of June 1, 2015. 33, the Board of Adjustment determines to substitute its independent judgment for that of the Planning and Zoning Commission on disputed issues and findings of fact under AMC 2150-80C through D. Board of Adjustment finds the goal of land use regulation of cell towers are better served by waiving and reducing the burden on the applicant with respect to the proximity of the tower structure to residential structures and residential district boundaries, in parentheses, the minimum separation distance and 200% quote fall zone unquote described in AMC 2145-265A16B. Reduction of the minimum separation distance and waiver of the 200% fall zone are approved and incorporated in granting the appeal and confirming the conditional use permit as stated herein. Can I have a second, please?
Second.
Thank you. It's been moved and seconded to insert the paragraph that I just proposed. And I intend to vote for the motion for the reason that it is apparent from the city attorney's motion for reconsideration that it was simply not understood what we had done. And it seems to me that by inserting this paragraph, that we will substantially clarify matters and explain to, not only to the planning department, not only to the city attorney's office, but also to the public and to the many people who are here today who are obviously interested in this issue, what we had in mind and how we came to our decision and what we actually decided, so that it is crystal clear that we simply view the matter of the fall zone issue to have been addressed already in the motion. The main motion that the Planning and Zoning Commission considered in ruling on the conditional use permit. It is therefore my intention to vote for the motion. Mr. Stewart.
I think this motion captures the general land use goals and puts it into perspective on what we're doing, so I intend on voting approval for this.
Mr. Adams.
I think it very clearly states what action we took and exactly what it was targeted at, so there's no misunderstanding with respect to what action was taken, and addresses one of the two things that I addressed with the petitions.
Okay, I have no further discussion. Madam Clerk?
Baron Gutschall,
Yes.
Robert Stewart,
Yes.
Dwayne Adams.
And the motion passes 3-0. There is concern, at least on my part, that perhaps the planning department and also the city attorney's office and the public that is reading our decision does not quite understand why we believe the planning department does not have any authority to rule on the separation issue under the facts of this case. We discussed this at great length during our deliberation on this case, on this appeal, and apparently it didn't come through clearly enough. I think we would be remiss in our obligation to explain our decision sufficiently and to make it clear exactly what we have in mind and how we view the municipal law to work in this case by providing more guidance and guidance in the form of conclusions that I intend to offer as an addition later on. But before I can do that, we need to further move and perhaps concur that the findings and decisions of the board of June 1 should be further amended by including additional conclusions that explain in some greater detail how we view the interaction between seemingly confusing code sections to work and what the planning department can and cannot do without going back to the Planning and Zoning Commission. And so I move that the findings and decisions of the Board of Adjustment dated June 1 shall be further amended to clarify that issue. May I have a second, please? Mr. Adams, thank you. Again, I think we need to do all we can to clarify our decision. There are conflicting sections, seemingly conflicting sections of the code. One of them is that the planning department can rule to reduce and eliminate the default zone requirement of the supplementary district regulations. How does that work in interaction with a conditional use permit pending before the Planning and Zoning Commission? If the planning official is allowed to rule on the default zone issue after the conditional use permit has been issued, in essence, the planning department can negate what the Planning and Zoning Commission has done. And clearly, that cannot be the law. It is therefore, and the reason that cannot be the law, I should say, is because the Planning and Zoning Commission clearly is the governing body here, and the planning department simply is in a subservient position. And so it should not be, and it cannot be, that the office that is in a subservient position to the Planning and Zoning Commission can overrule and in fact negate any decision of the Planning and Zoning Commission. And so I believe that we need to amend our decision to make that clear, because I think we can work the seemingly conflicting decisions, provisions of the code, so that they work together, because there is a logical explanation that we have for that. And it is for that reason that I intend to vote for the motion to amend our decision to clarify that working between seemingly conflicting sections of the municipal code.
I would add to that in the appeal, there's no recognition that was even an issue, and it's even brought forth in a rather graphic way when it says that in its conclusion with respect to what action this board should take, that we should actually remand it back to the administrative official to fix the problem that we identified, which is absolutely counterintuitive and actually is at best is an MCS or wrong, I would say. The attorney simply missed that whole point and obviously did not connect those dots, and by fixing the problem, by perpetuating the problem, is not a solution. And it was very clear in the actions of the commission, as well as in our discussion, that the key was the very thing that Mr. Buchow just brought forth, that you can't have a subservient body overriding a decision made by a superior body. And the attorney simply dismisses that and tries to perpetuate the problem, and that's simply not acceptable, and just as a matter of law, then.
make these decisions. And the appeal authority from that comes to the Board of Adjustment. It doesn't go to the administrative authority that's providing advice to the commission.
Ms. Tucker?
Mr. Adams, when I heard as listening to the preliminary statement that you made, you said that you referenced things having been missed in the appeal, and I think that you were referring to the motion for
Oh, I'm sorry,
reconsideration.
yeah,
I'm just correcting
yes.
that for the
Thank you.
record. I
The
understood
motion
it,
for reconsideration.
but when it's
Good.
flat on the transcript, it looks odd. And then.
Thank you for that clarification.
And then the item, and you may be bringing this up also, but something that was mentioned when the board was discussing this at the deliberation hearing, was that a decision of the administrative official is appealable to the Planning and Zoning Commission in the same manner that the Planning and Zoning Commission, as you've just pointed out, appeals to the Board of Adjustment. So as counsel to the board here, I totally agree with that conclusion, that it would have been inappropriate to do what the municipal attorney is asking the board to do on reconsideration, and that is to somehow come up with a direct remand from this body to planning staff.
Okay, any further discussion regarding the motion? Seeing none, Madam Clerk?
Baron Gutcho,
Yes?
Robert Stewart,
Yes.
Dwayne Adams.
Yes.
The motion passes 3-0. All right, having then decided that we need to provide some clarification, we have some suggestion here that our council provided us. And it is rather lengthy. And so I would like to first take some time for all of us to review this to make sure that we understand what the proposal is. I will then entertain a motion to adopt the additional conclusions. And so we will proceed in that fashion. I will not read all of these changes into the record. I will simply refer, well, let me backtrack. Do I need to read this into the record, or can we simply refer to what you suggested? I'll be happy to read it into the record if you feel that.
I think that it's better to read it into the record.
All
I'm
right.
sorry for that. but
Otherwise
No, that's
it's
okay.
good.
That's okay. I will read then the proposed addition into the record by way of making a motion. So, first order of business then is to review the proposed changes that we have written out here. And when we are done with that, I will make a motion.
It's your decisions. Right, I was just looking at that.
Any decision? Okay.
Yes.
Okay.
Great. I didn't leave it out of the document, but I did leave it out.
Okay, I will move that we add the following as, that we will add the following paragraph 6 to the conclusions. Remember, we have, all our decisions should have findings of fact, conclusions, and decision. So I'm proposing, and I so move, to add the following conclusion. Numeral 6. There is sufficient evidence in the record on all issues material to the decision, and the procedural error on the part of the Planning and Zoning Commission does not require further public hearing. Remand to the Planning and Zoning Commission is neither required under AMC 2110-100 nor necessary to finally dispose of the matter on appeal. Small a. AMC 2145-265-16C offers an administrative avenue for reduction or elimination of the minimum separation distance of 200% of the allowable tower height, in parentheses, the 200% quote fall zone, unquote, close parentheses, within supplementary district regulations for tower structures, provided that the site plan application otherwise meets the supplementary distance regulations for administrative site plan review and approval. Paragraph small b, by operation of law, structures qualifying for administrative site plan review do not require a conditional use permit from the Planning and Zoning Commission. AMC 2150-280A1, paragraph c. The administrative official is authorized to administratively grant site plan removal. AMC 2145-265A14D2. The administrative official has no authority to grant a conditional use permit. Small d. AMC 2150-280C allows the Planning and Zoning Commission to waive or reduce the burden of the applicant on height and proximity standards. The supplemental district regulations for site plan review do not require both a conditional use permit and an administrative waiver of the minimum separation distance under AMC 2145-265A16C, nor is an administrative waiver a mandatory condition precedent to conditional use waiver or reduction of the height and proximity standards. E. The decision of the administrative official on administrative site plan review is appealable to the Planning and Zoning Commission. AMC 2145-265A14H. F. Under the facts of the present case, referral to the administrative official for an administrative waiver of the minimum separation distance under 2145-265A16B, in parentheses, relief from the 200% quote fall zone, unquote, distance, close parentheses, after the conditional use permit is granted, would be tantamount to giving the administrative official after the fact control over the conditional use approval. The Board of Adjustment concludes this to be inappropriate as a matter of law. G. There is no authority in code for an administrative waiver application to be granted or denied by the administrative official after the conditional use has been approved. That's the motion, to include those portions that I read. May I have a second, please, for discussion purposes?
Second.
Mr. Stewart has seconded the motion. I think the addition of this number 6 and the 7 subparagraphs sufficiently clarify and should make it clear to both the department and to the city attorney's office and to the public that is reviewing our decision how we came to the conclusion that we came to. And it is for that reason that I intend to move in favor of my motion.
I
Mr. Stewart.
think this sets out the logical sequence for how we interpret the law and how planning and zoning and the general public can look at this now and interpret it in a likewise version. I will support this.
Okay. Mr. Adams?
I will support this, just as a minor amendment, I believe you stated in the very first paragraph, 21, point 10, point 100, I believe it's 21.30, point 100. But I do intend to support it, based on the fact that it provides a reasoned step-by-step explanation of how we came to that, and addresses the point that was missed by the attorney, for which we have a concern.
Thank you for the correction. I misspoke, obviously. One additional comment. By making this motion and inserting these paragraphs, we are not doing anything new. We are not coming to a different conclusion than we came to before, and as stated in our decision of June 1, 2015, it is simply that we are clarifying how we arrived at our decision. And I think this will provide everybody a sufficient understanding of how we arrived at it. Perhaps we were remiss in not including this before, and that's where the confusion arose, both on the part of the city attorney's office and on the part of people reviewing this decision. So it is for that reason that as I said before, I intend to vote for the motion. Any further discussion? Seeing none, Madam Clerk?
Yes.
Just 1 second. Yes, Ms. Tucker?
To my hearing, and this is just, may have been incorrect, but also when you were going through this lengthy resuscitation, in subparagraph C, I heard you say site plan removal, and it should be site plan approval, and I'm just making that
Approval.
correction in case and if I didn't hear you correctly, then I apologize, but just for the record,
Well-
out of an abundance of caution, I'm saying
Well,
that.
thank you. It's entirely possible that I made a mistake. On the other hand, remember, I'm just a first-generation immigrant to this country. It could be that my English was good enough.
It could have been.
So, anyway.
Could have been my hearing, as I call it.
Any further discussion? Seeing none, Madam Clerk?
Baron Gutschall.
Yes.
Robert Stewart.
Yes.
Dwayne Adams.
And the motion passes 3-0. All right, there is one additional item, and that concerns the wording of paragraph 31, which was the troubling section that apparently caused the city attorney to justify the motion for reconsideration. And in looking at section 31, it is entirely possible that we did not state things clearly enough. And so what I will do is I will offer a motion that finding of fact number 31 be amended as follows, without rehearing. 31. Action by the Planning and Zoning Commission as the administrative official is null and void for lack of jurisdiction, period. The foundational Planning and Zoning Commission record supporting conditional use approval is intact. That is the addition of a sentence that precedes what is there in section 31 now. And to add by operation of law, following the words Planning and Zoning Commission in the next sentence. So those are the changes I'm proposing for paragraph 31 of our decision of June 1. I have moved, and Mr. Stewart
Second.
seconding that motion. Let me briefly speak to my own motion here. The city attorney's office motion for reconsideration is confusing. We've discussed that before. And it is more a substantive argument with our decision than a procedural one. And the city attorney focused in his motion on paragraph 31 and said, here's the evidence that you simply misunderstood what was happening. Well, I think by adding the sentence and by adding, quote, by operation of law in the location that I've specified, I think we are significantly strengthening what we have said before and what we intended to say. And so it is for that reason that I intend to support my own motion. Mr. Stewart.
I think the biggest key item here is by operation of law, in my perspective, because that is what we had lengthy discussions about, and that is exactly what we intended. And I think just that phrase alone helps a lot to clarify exactly what we were doing and why we were doing it. So I will support this motion.
Okay. Mr. Adams.
I agree, just to the foundational discussion, we spent a lot of time talking about those 8 considerations that were part of the global decision with respect to the planning and zoning action, particularly on conditional use. And so this clears that up and makes it very clear to all parties what the intent was.
Okay. I have no further comment regarding this motion. Madam Clerk?
Janet Puccio,
Yes?
Robert Stewart.
Yes.
Dwayne Adams.
And the motion passes 3-0. In looking at our decision of June 1, 2015, I find that we made another error, and that is, remember what I said before, every decision by this board needs to consist of findings, conclusions, and a decision. And when you look at what we did on June 1, it does not have anything that is entitled decision. Although when you look at it, you will note that the last 3 paragraphs are in fact decisions. They simply are not stated as such. And it is for that reason that I want to amend our decision by clarifying that. And what I'm suggesting is that the last 3 paragraphs of our decision of June 1 be labeled decision 1, 2, 3, and that we, so that's the first. Let me just stop right there, because I have a couple further technical amendments. So that's my motion. So that we add the section entitled decision. And the decision consists of 3 paragraphs, and they are what is currently referred to as conclusions 6, 7, and 8. Does that make sense?
So moved.
All right. Thank you. And Mr. Stewart has seconded that motion. Mr. Adams?
I think, yes, we should have something that's very clearly states what the result of our actions been as a decision. Those 3 are indeed the specific actions.
All right, Mr. Stewart?
That was a good catch, because a final decision is in fact necessary in order to appeal to this period. So, good catch.
Okay. All right. Any further discussion regarding this motion? Seeing none, Madam Clerk?
Barrett Goodchild,
Yes?
Robert Stewart,
Yes.
Dwayne Adams.
Yes.
And the motion passes 3-0. Then our new decision, and the way this is going to work is that our trustee council will redraft what will be entitled amended and restated findings, conclusions, and decision. And it also needs to reflect, of course, what we're doing here today. And so regarding decision number 1, that we have just labeled as decision number 1, needs to have a sentence added, and that sentence should read, approval of the conditional use permit is confirmed as set out herein and referred in attachment A. Furthermore, that we change decision number 3 to read, this amended and restated finding, conclusion, and decision is a final decision. Nope, I'm sorry, I misspoke. This amended and restated decision is a final decision of the Board of Adjustment with respect to all issues involved in this case. The parties have 30 days from the mailing or other distribution of this, and add amended and restated decision to file an appeal to the Superior Court. As I said, I move to make these changes to reflect what we are doing tonight. And may I have a second, please?
Second.
Has been seconded by Mr. Adams, thank you. We need to reflect, to have the decision reflect what we are doing here tonight. And my additions simply have that effect, and they clarify it that the appeal period runs anew, although we know there has already been an appeal filed of our decision of June 1, but the appeal period runs anew as to the amended decision for 30 days from the mailing or other distribution of our amended decision. So that's what this motion is intended to do, and I intend to vote in favor of it.
I intend to vote in favor, but I would ask Julia, with respect to this amended and restated decision, we know that there's been an appeal filed with the Superior Court. Recognize there's members of the public here, do they need to file a separate appeal to the Superior Court, recognizing we already have one there, since this is a new decision or an amended decision?
Well, certainly they'd have to inform the court that the decision has been amended and restated. And then they would have to ensure that their arguments are still geared to this decision. And since they have a new 30-day period, they have time to do that. So I think it behooved people, because it wasn't clear, the motion for reconsideration could have been denied without any change to the opinion. And if that had happened, then the 30-day window was running. So I think when there's a reconsideration, I'm sure they have counsel to advise them, and I really can't be their counsel on that.
Their appeal would be wise to file again to Superior Court.
It would be wise for them to contact their attorney and to make sure that their appeal reflected this decision, and that they let the court know this decision, and beyond that, I'm not available
You're
to
not
give
their
them.
attorney.
Yep.
Okay, thank you. Glad you.
Okay. Any further discussion, Mrs. Stewart?
No, I think by this amendment and that paragraph at the end of the decision, that also lets the people that are filing pro se know exactly where they stand and what they should be doing.
Okay. I have no further discussion. Madam Clerk?
Barrett Goodchild,
Yes?
Robert Stewart,
Yes.
Dwayne Adams.
Thank you, and the motion passes 3-0. All right, we now need to simply address a couple of housekeeping measures regarding this. And the first one is that our trustee council will prepare findings and decisions regarding this, regarding the motion for reconsideration that we have disposed of, as it were. And the second one is that she also needs to prepare amended and restated findings, conclusions, and decisions. And we need to agree on a date when both of those documents will be considered by us at a public meeting, as we always do when we have reached decisions. And it should be fairly quickly, so that we can finally dispose of this case. And my first question, of course, is going to be to Ms. Tucker. When do you think you can have this done?
I was wondering, the board is here this evening, you're going to be hearing another matter. Although I have a 8 o'clock commitment, it may be possible for me to confirm what the board has decided this evening and bring it back to you while you're here. Absent that, I would depend on the board's decision on when their next available date is. Tuesday, the 14th and the 28th of July are out for me, but other than that,
Are you saying the 14th is out for you?
yes, the 14th of July is, am I right?
That's
Is the
Tuesday.
assembly meeting, is a Tuesday, is
Tuesday.
an assembly meeting. So other than that, other than those two assembly dates,
Okay, all right, so
Um,
what you're telling me really is that you can either have it done by 8 o'clock tonight, if we get done with our other matter, or we need to pick a date next week.
right,
Okay, so why don't we simply, for the time being, postpone this to follow our other agenda item, which is consideration of appeal number 2015-1?
right.
Which
And
we
if I'm-
anticipate.
And if I'm not able to complete it by 8 o'clock, you'll know and we'll
And
set a date.
then we will set a date as, yes.
And did-
If I may on this, the next case, I have a conflict of interest. I'm not going to be here, nor do I feel comfortable.
Oh,
sitting
that's,
in the room.
that's
Oh.
true, that's a
Oh, good
problem.
point.
How about,
Yeah.
so we can't do that? So we can
Or you can
scratch
call
the
me
8
at home.
o'clock? No, we're not going to
Yeah.
do that. No,
Yeah.
we're not going to do
Yeah,
that.
you have to do
So
that.
we will have to
Forgot
do
about
this
that.
next week, and the question is, are you two available next Wednesday at 4 PM? I'm just
Yes,
trying to,
Monday would work as well.
no, I can't do it Monday.
Wednesday's fine.
Wednesday is
4
fine?
o'clock.
4 o'clock Wednesday?
4 o'clock Wednesday it is.
I failed to bring my calendar for next week. I think I can do it on Wednesday at 4. I know there's something going on that day. I just don't think it's later in the afternoon. I think it's early. So for the time being, why don't we leave it at 4 o'clock on Wednesday, the 15th? Is that okay with you, Madam Clerk?
That's great.
Okay, so why don't we leave it for that? We'll meet again regarding the formalization of.
4 to 4:30.
It will not take longer than half an hour.
And we'll have the decision out to you. I'll have, between Lisa and I,
We'll get a pre-look at it.
we'll get, you'll
Yeah,
get,
yeah,
look at it,
please
so you
do.
won't have to look at it.
Please do, so.
And I do have additional notes in the back that I didn't have. I should keep fresh. Maybe let me
You
make
can
a
have
copy
that.
of those.
You can have that. Okay. All right, very good. That will conclude our consideration of the motion for reconsideration, and we will stand in recess until 5:30. Thank you very